Dr. Farwell.
Yes.
Have you seen this?
What blasphemy?
Mr. Farwell, do you think that any reasonable person would actually believe that you would have sex with your mother?
No, it's an absolutely absurd idea. A good Christian like me would never fornicate with their mother. It's just absolutely ridiculous.
Well, do you remember what Judge Turk said in the beginning to the jury during the instructions on libel?
Yes.
Do you remember what he stated the first question for them to answer?
He stated that if a reasonable person could believe what was being said in the advertisement, then they would have to move on to the next step.
So, did you just state that a reasonable person would never believe a parody such as this?
Yes, I did.
All right, Larry, when you decided to publish the Campari parody in the Hustler magazine, were you intending to make him look out to be like a liar?
You bet your ass I was.
Okay. Did you ever think that you were attacking his profession as a pastor?
Yeah, I did.
Were you trying to destroy his integrity?
I was trying to assassinate it.
I'm an odd duck. I watch the Weather Channel, ESPN, and then if there's a good heavyweight fight on what is shaking the earth, I don't care what the Bantam lightweights and all. I mean, they're jumping around, pecking on each other. I like the big, the big heavyweights who get with it in there.
Alan,
But
I
I
want
watch
to
the
appeal.
Weather Channel sometimes.
Larry, libel wasn't proven. Jerry Falwell's own testimony proved that no one would believe that he would have sex with his mother. But on the account of intentional infliction, you were found guilty. You have to pay $100,000
Pennies.
in compensatory damages and another $100,000
Pennies.
in punitive damages. It could have been a lot worse.
I want to appeal the case. I don't think I should have been found guilty on anything.
It's true, the jury finding you guilty on intentional infliction for emotional distress is probably going against the First Amendment. But I'm not taking you on appeal, Larry. Grutman should have been thrown out for giving $10,000 to Bill Ryder, and the deposition being admitted did not help our case. But I'm not taking you to appeal, Larry. Everything is a joke.
Alan, I need this. You're my friend. You're the only person I trust. We need to win this one.
Ready? I completely agree with Judge Turk's decision to throw out the appropriation of name or likeness claim. The advertisement was a parody and was not using Falwell's name or picture to make money, so it was correct for that claim to be thrown out. Hustler and Flynt's argument points out that we should not be able to use a tort to punish a person for verbal abuse. The New York Times Company sets the standard. However, the way Larry Flynt spoke throughout the trial indicates the intention to assassinate Jerry Falwell's reputation, causing emotional distress. Therefore, we affirm the decision of the lower court.
Mr. Chief Justice, and may it please the court. According to Brandenburg versus Ohio, our First Amendment rights of freedom of press cannot be squashed because people do not like what is being said. The only time that freedom of press can be set aside is if the reporting causes a riot. The advertisement did not cause a riot because it was a parody. This decision by you, the Supreme Court, was upheld in Hess versus Indiana. When Hess screamed that he was going to fucking take the streets, you determined that he could not be convicted for just saying the word fuck. It goes against our First Amendment right. And finally, the most important case in our defense is Cohen versus California. Larry Flynt did not force his opinion on the people. People who by hustle voluntarily looked at the advertisement. It was not forced upon them. They could have averted their eyes and not looked at the magazine. The government cannot give forward money for something that he voluntarily looked at. There was no violence caused by our advertisement. So the decision of the intentional infliction of emotional distress should be thrown out. We should not award money to people on the sole basis of them being insulted.
Larry, we've got our decision from the Supreme Court. What was the decision, Alan?
We won, Larry.
Are you fucking shitting me?
The Supreme Court reversed the decision by the jury and we won the case.
No fucking
They
way.
agree with us. They agree with us. They believe that we shouldn't have been charged damages
Oh, fucking
for
way.
intentional infliction of emotional distress after libel was dismissed.
Wow.
We actually won the case. We won the First Amendment.
That's great news, Alan. Thank you for everything.